Today is that day.
Dirty cops make things a lot worse than they should be, but sometimes they get to face the consequences of their actions. In this video, we will look at cases where dirty cops instantly get killed in the courtroom. Starting with the first one, where an angry judge destroyed a cop's whole life. Former Sheriff Jamie Null of Clark County grabbed headlines when he was found in contempt of court for violating his bond conditions by possessing multiple firearms in his residence. This controversial figure, famous for his stint on the A&E show 60 Days In, also faced accusations of embezzling millions in local funds for personal gain. The judge's surprising judgment in this case will truly leave you astonished.
I told Mr. Null, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody.
We need more dedicated judges like him who are passionate about serving the public and standing up for justice. It's time to show corrupt cops that their actions will be punished.
No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be right there with me. Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find that Mr. Hurdle's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. It really did. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there, it's my friends. I'm not buying it. It's your burden, it's your responsibility, and today the court will enforce that. Take it on.
This is what dirty cops like him deserve, to rot in jail until their demise. Thanks to the judge's fierce decision, people across the states can rest peacefully knowing that we are in good hands. If you think this cop was tough, then watch this next one who thoroughly exposed a criminal cop before giving him a fierce sentence.
Eric DeValconaire on count 1, the Class E felony of involuntary manslaughter in the second degree.
On Friday, March 4th, 2022, former Kansas City police detective Eric DeValconaire, who was convicted in November of Cameron Lamb in Kansas City, Missouri, appeared in front of Judge Dale Youngs. The way the judge hands down the sentence is a sight to behold.
There are a number of facts in this case that are both aggravating and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead, and Eric DeValconaire killed him. That's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel. Also, as I'm weighing all these facts, it can't be overlooked that the events of December 3rd of 2019 were initially set into motion by Cameron Lamb and his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk. However, those events tragically concluded with the actions of Troy Chauvin and the defendant, pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option.
Lamb, 26, was backing his pickup truck into his garage when DeValconaire shot several times, and he died.
At any point, Sergeant Schwam and the defendant could have done this, a fact that is made even more aggravating as the court considers an appropriate sentence, in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway, under the carport, and into his garage. And as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. The circumstances of the offenses described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValconaire, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house.
DeValconaire said Lamb was armed, but the prosecutors believed that the firearm found near him was placed there intentionally.
Negating his obligation to act with reasonable care, as the court found he has failed to do, his natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction, I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things. Eric DeValconaire is not Derek Chauvin, who murdered George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality of the defendant's life. The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him, as it did on December 3rd of 2019. All of which, however, leads the court back to where it began, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family.
The judge did a great job of explaining to everyone that he was not biased against the officer. He also mentioned the impact on the deceased family, so both sides felt heard.
And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded as I have, having considered all those factors, I ask counsel if there's any legal reason or cause, having been shown, why sentence and judgment of the court should not now be pronounced.
Sir.
Eric DeValconaire, on count 1, the Class E felony of involuntary manslaughter in the 2nd degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
The Balcanere was sentenced to 3 years for the involuntary manslaughter conviction and 6 years for armed action. Although the sentence sounds short, his life after getting out was essentially over. If you think this officer had it bad, then wait till you see this next officer who was being cross-examined for arresting George Floyd.
And Mr. Floyd didn't drop while you were interacting with him, correct?
No.
Derek Chauvin is the officer who previously arrested George Floyd. He was a former Minneapolis police officer involved in Floyd's fatal arrest on May 25, 2020, where he knelt on Floyd's neck for over 9 minutes while Floyd was handcuffed and pleading for air.
Testified that you were the officer who approached the passenger side of the vehicle. You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd, isn't that right?
Yes, I pulled it, yes.
And when you approached Mr. Floyd, he said, "Don't, man, I don't want to get shot."
Something like that, yes.
You told him to undo his seatbelt, correct?
That's correct, yes, ma'am.
And he did that, right?
Yes, he did.
And then you said, "Put your hands where I can see them," correct?
Yes.
And then he put his hands in the air.
Yes,
And then you told him to put his hands on the dash, is that right?
that's correct.
And that was when you grabbed his hand and forcibly put it on the dashboard of the vehicle, correct?
Ron, yes.
This incident led to widespread protests and calls for police reform across the United States and globally. Watch how Chauvin's expressions change as he gets cross-checked.
And then he put his hands on his head, right?
That's correct, yes.
And there was one officer who said that they were going to take him, right?
That's what I heard, yes.
And you were yelling pretty loud, correct?
Yes, I was, yes. It escalated real quick.
Some profanity as well, correct?
Yes.
And you had your gun drawn the whole time you were giving commands, right?
Once I started ordering him and he refused to show me his hands, yes, eventually it escalated to where I pulled my gun, yes, ma'am.
And he was awake, correct?
What's that, ma'am?
Mr. Floyd was awake. Was he awake during this incident?
Yes.
He was conscious?
Yes.
He didn't appear to be in medical distress to you when you were pulling him out of the car, is that right? He was standing up, is that right?
I don't know if it was specifically, sometimes he was talking, sometimes he was mumbling. He was incoherent in my mind a lot of the time during there.
But you got him out of the car and you handcuffed him, right?
That's correct, ma'am.
And he stood next to the car, right?
Yes, ma'am.
He asked you not to beat him up, correct?
That's correct, yes.
He was able to walk, right?
Yes, he was.
He continued to talk to you. While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
Wait a minute, what was the question? Can you speak up a little louder, ma'am?
While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
No, he did not.
Well, the answer is stricken. The objection is sustained.
Your attention was focused on Mr. Floyd, correct?
Yes, it was.
And Mr. Floyd didn't drop while you were interacting with him, correct?
No.
Thank you. Nothing further.
Chauvin was charged with multiple offenses, including second-degree unintentional murder, third-degree murder, and second-degree manslaughter. He was convicted on all counts in April 20th, 21, and subsequently sentenced to 22.5 years in prison for his role in Floyd's death. Next up, we have the case of an ex-cop who was involved in one of the most heinous things an officer could do.
Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter.
In October 20th, 19, former Fort Worth police officer Aaron Dean appeared in front of a Texas jury for fatally shooting Tatiana Jefferson in October 20th, 19. His guilty verdict was a rare conviction of an officer for killing someone who was also armed.
Good afternoon. The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor. The defense is ready, Judge.
All right. Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring them in. Good afternoon. Juror number one, it's my understanding the jury has reached a verdict, is that correct?
Correct.
Is it a unanimous verdict?
Yes, Your Honor.
Okay, if you hand it please to Deputy Nicholson. Mr. Dean. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Members of the jury, as we went through before, I'm going to call your juror number and ask you if this verdict is your individual verdict.
Notice how the devil cop failed to show any emotions. It's as if he didn't want anyone to see that they could get to him.
Number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 14, is this your verdict?
Yes, Your Honor.
Juror number 15, is this your verdict?
Yes, Your Honor.
Juror number 21, is this your verdict? Juror number 31, is this your verdict?
Yes, Your Honor.
Juror number 32, is this your verdict? Juror number 37, is this your verdict? Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice from the date of your original arrest up until today, which would be the date of sentence. You have the right to appeal the jury's decision. You do so by giving written notice of appeal to the Second Court of Appeals here in Fort Worth within 30 days. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Mr. Gill, Mr. Brissett, if y'all will remain on this case pending his decision whether he wishes to appeal, and if you'll furnish the information for the trial court certification of appeal before you leave here today, I would appreciate it. Is there an allocution? You may be seated. Thank you very much.
The jury took about 13 hours to reach a decision and ended up finding Dean guilty of manslaughter instead of the more serious charge the prosecutors wanted. Dean's defense argued that his actions were reasonable given the circumstances, but the jury went with the lesser charge in the end. Do you think the jury made the right decision? Let me know in the comments below. And if you liked the video, subscribe so you don't miss out on the next one we have in store for you. Thanks for watching. This is Detective Mystery, signing off.